So when I was in law school, which was shortly after the Jefferson administration, separation of powers law was not considered an exciting topic. That's not where the action was in constitutional law. But I became interested in the structural side of the Constitution, the relationship between the branches of government, in large part because of the work I did for a few years as a Justice Department lawyer. And as luck would have it, it turned out to be a growth area. Obviously, the topics that I try to read and write about have become of great interest. Unfortunately, things that are good for my writing tend to be bad for the country, and this may be an example of that. What I thought I would do is just speak only for a few minutes and then respond to whatever questions or conversation you want to have, because we only have an hour together. And I always do this with a little trepidation, because the presidency holds such a looms so large in our collective imagination that there are always people who are just into it, at a vast level of detail. And I'm sure that there is somebody in this room who will know things about the presidency that I don't, whether it be the thread count in the Lincoln bedroom, or I don't know. But I don't necessarily assume that I'm the most knowledgeable person in the room. I just may be the most experienced when it comes to thinking about these issues. So impeachment is mentioned 4 times in the US Constitution. There is the provision in Article 2 that indicates that the president and the vice president and all civil officers of the United States shall be removed on impeachment for treason, bribery, or other high crimes and misdemeanors. Then there are 3 provisions in Article 1. The provision that gives the House the sole power to impeach, which is really, as I'm sure we all know, a kind of indictment. The provision that gives the Senate the sole power to try impeachments. And then there's a provision that indicates that says that the punishment for impeachment shall go no further than removal from office and disqualification from office. And interestingly enough, that those 2 things happen, if they happen at all, in different votes. So it requires a 2/3 vote of the senators present to convict on impeachment. But under Senate rules, if someone is convicted on impeachment, they're subject to a possible second vote that would disqualify them from any further federal office holding, and that vote is carried by a majority. Interestingly, there is a long time now, 25+ year member of the House of Representatives from Florida, a Democrat named Alcee Hastings, who used to be a federal judge. He was impeached and convicted, but not disqualified. And stepping off the bench, he then kind of stepped into electoral politics, and he's been a House member ever since. Just a few of the basic points. Again, I don't think any of these will necessarily be surprising to you, but one reminder is that impeachment is a civil proceeding. It is not a criminal proceeding. Indeed, the point of the part of Article 1 that says punishment shall go no further than removal from office and disqualification is that in England, when there were impeachments, there could be a 3rd part, which was the we throw you into jail part. And so by limiting the punishments, there was the intention was clearly expressed that this would not be a criminal process. This would be a process simply to get out of office civil officers of the United States who are abusing the public trust and injuring the republic. Consistent with that, again, commonly known, the phrase treason is treason, and by the way, treason has a legal definition. It is not what anybody on Twitter wants to call somebody they don't like. That's not actually treason. Bribery. Then there's the phrase other high crimes and misdemeanors. The high in high crimes and misdemeanors refers to the augustness of office. But the phrase high crimes and misdemeanors is not a reference to the criminal code. That is, high crimes and misdemeanors is itself a term of art that refers to those abuses of the public trust sufficiently gross, of sufficient magnitude to warrant removal from office. So there was no agreed upon definition in England. I mean, it's just, and impeachments were not happening. Really, the enthusiasm for impeachment had sort of waned by the time the turn of the 18th to the 19th century. But there was not a settled definition of these are the specific things that can get you impeached and removed, and that's not true in the United States either. Rather, this is decided pretty much based on precedent, but it's not. President Ford, when he was Speaker of the House, famously said that an impeachable offense was whatever a majority of the House agreed upon. And in practical terms, maybe that's true, but it's not really true to the constitutional sense, which does envision that high crimes and misdemeanors really be offenses against the public trust, again, that undermine the republic. When it comes to how the House and the Senate conduct their proceedings, the House conducting its investigation and votes and the Senate conducting its trial, they make their own rules. The only thing that is said with regard to Senate trial procedures in the Constitution is that the senators must take an oath before they sit as this kind of de facto impeachment jury. And if the president is the subject of impeachment, then the officer who presides over the impeachment is the Chief Justice of the United States. And by the way, I just throw this in because there are some people who believe that the constitutional text answers all questions. It doesn't. One of the questions it doesn't answer is what happens if the vice president is impeached? Because the vice president, of course, is the president of the Senate. So if you read Article 1 literally, the vice president would preside over his own impeachment, which is one of those things that cannot be true. So, but there's no textual resolution of that in the Constitution itself. Really, I'm not sure that there's any other sort of, I'm happy to say anything else that ought to be said in response to whatever questions are on your mind. We can talk about the history of recent impeachments. We can talk about, the specific allegations at stake here, or the procedures involved. And again, if I've already spoken in error, you should correct me. And if there are things that you want to add to our factual understanding, you should feel free to do that as well. But I'm happy to respond. Yes?
So my question lies in where impeachment moves after the House. Because I understand it ends at the House, but then it has the capability to go forward into the Senate in a different manner. But I don't think I know enough about that.
Right. So what happens is that a message is literally delivered to the Senate so that they are formally presented with the articles of impeachment. And then the Senate sets about deciding when the trial will start and implementing its own procedures. The procedures, I think, are set forth in the Senate manual, but there can be variations. There's been some talk, and this happened in the Clinton impeachment as well. There was some talk about maybe we don't have to have a trial. If we think that the charges are not high crimes and misdemeanors, maybe it would be in order for someone to move that the Senate hereby finds that these charges are not adequate to support impeachment and removal, and could just forego a trial. It didn't happen in the Clinton case, and although my crystal ball comes with famously weak batteries, it's not going to happen here either. They're not going to take a vote to not have a trial.
So they will have a trial?
I believe so.
Thanks for clarifying.
I'm sorry?
Thanks for clarifying.
Yeah. Yes?
Is that all under the purview of Mitch McConnell, and in assuming worst outcome, does he have the power to just be like, we find the president guilty of being a great guy, like, you know, how much power do they have over the content of the Senate side of the?
Well, they have complete control over the procedures, except that the presiding officer is going to be John Roberts. John Roberts is famously reputed to be a serious institutionalist. He doesn't like it when his role as Chief Justice is taken lightly or described merely politically. So, you know, I don't think he would want to be perceived as overstepping his role in limiting the discretion of the Senate Majority Leader, but I'm pretty sure that if the Senate Majority Leader were of a mind to decide this by Ouija board, that there would probably be some resistance to that. You know, the Senate Majority Leader has a lot of power over what comes to a vote and when. The procedures, again, the procedures are the procedures that have been set forth. The Senate can take a vote to depart from those procedures or to adopt different procedures. Again, I suspect that the various kind of dirty tricks scenarios for bringing this to an end, I don't think are going to happen. But this could be my naivete. Yes, sir.
So this is my first impeachment, so I'd like to know what your perspective is on the severity of the allegations and the severity of public outcry compared to previous attempts at impeachment.
Right, so that's great. In law, we call that a compound question. So, you know, a lawyer will stand up and say, I object, that's a compound question. So we'll separate the two questions, the seriousness and the public outcry. So this was not, if we want to speak about this in personal terms, this is not my first impeachment. My first impeachment was not the Johnson impeachment, I want to say that. It was the Nixon impeachment. And just, I can't resist one tangent. So in the summer, you know, of the summer of impeachment, as it were, I was still, I was spending it in Cambridge, Massachusetts. I was a Harvard undergrad. And there was a television set in the second floor of the school newspaper, which is where I mostly hung out. And it was there that I watched John Dean testify. And 45 years later, I was asked by the Senate Democrats on the Judiciary Committee to testify about executive power issues as they related to the nomination of Brett Kavanaugh to the Supreme Court. And one of my co-panelists was John Dean. All I can say is, if you think you know what's going to happen in your life 45 years down the road based upon what you're seeing on television today, no. There are surprises ahead. So I would say this. The charges against Andrew Johnson, and this can get complicated, but it was basically a setup, right? I mean, what were then called the radical Republicans in Congress, the folks who wanted the Civil War to mark not just the end of secession, but really the end of the Southern, what they believed to be the Southern caste system. These are the sort of champions of the 13th, 14th, and 15th Amendments. They had a plan for Reconstruction that was very much not Johnson's plan. And they wanted very much to get rid of him because of it. He was clearly resisting what they wanted to happen, and he was vetoing civil rights bills and the like. So they created a statute under which anyone appointed with the advice and consent of the Senate could only be fired with the advice and consent of the Senate. So, fun fact, later on in the 1920s, the Supreme Court actually said that would be unconstitutional. Second fun fact, that is how Alexander Hamilton thought the Constitution would operate. That is, if you go back to the Federalist Papers, what he told the voters in New York is, if you're worried about instability in the federal administration, don't worry, because everybody that the Senate confirms will have to have Senate consent before they can be thrown out of office. And it turned out not to work that way, but it wasn't a silly idea. You know, Joseph Story, a very famous Supreme Court justice, in the early 19th century, early to mid 19th century, thought Hamilton was right, but history turned out otherwise. Anyway, Johnson fired Lincoln's Secretary of War, it was still called, Edwin Stanton, and which the Republicans in Congress knew was going to happen, and that's what they impeached him over. And he escaped by one vote. The vote for him was 2/3 -1. In terms of, I honestly, I wish Les Benedict from our history department was here. He could talk more about the public outcry. I'm not an expert in that. I will say it was sort of a disaster. I will say his acquittal was a disaster if you think that Reconstruction was a good idea. That is, if you think that really the federal government should have worked hard to disestablish the racial caste system. Because the fact that even with Grant elected thereafter, there was a kind of real weakening of that movement. So that's that. I do think the disobedience of that statute per se, I think one could have a good argument that that was not an impeachable offense, and I think that's why Senator Ross from Kansas, who was the deciding vote, decided not to go along with it. He just thought this was not the kind of a statutory violation like this was not the kind of thing that ought to be treated as a high crime or misdemeanor. With regard to President Nixon, if I remember correctly, there were 3 articles, basically the Watergate article, the abuse of the FBI, IRS, and CIA to go after his enemies article, including this is the break-in of Daniel Ellsberg's psychiatrist, the black bag job, and so forth. And then the third one was obstructing the Congress's investigation. And I felt at the time, and by the time the hearings reached their crescendo, not at the outset. At the outset, the public was more or less on Nixon's side. By the end of the hearings, they were not. And quite importantly, Senate Republicans were no longer on his side. So Barry Goldwater very famously led a Senate delegation to the White House to inform the president that if he persisted, he could not count on acquittal in the Senate, which is what led to his resignation. Those offenses, I think, are all but universally regarded as being sufficient to sustain an impeachment. And again, as I said, the public outcry kind of increased in magnitude over time. With regard to President Clinton, and this now is history you may well recall, or it's more familiar to you, 4 articles proposed by the Judiciary Committee, of which I think the House adopted 2. One was the sort of the Monica Lewinsky lying to the grand jury thing, and the other was lying in a court proceeding, which I think was the Paula Jones proceeding, if I'm remembering correctly. There were 2 other articles that didn't make it past the House vote. And interestingly, the House vote, this was done in December. The House vote was taken in December of 1998. The Democrats picked up seats in the 1998 election. If they had waited until the Democrats were seated after January 3rd, it's not clear that any of the articles would have gone forward. But the Republicans, Newt Gingrich was the Speaker, the Republicans took the vote, 2 articles went forward. And again, a lot of the debate, maybe even more than in the Andrew Johnson situation, was whether or not the charges were sufficiently serious to merit impeachment. Of course, the president's lawyers took the position no. The Democrats in the Senate and the House, by and large, took that same position. It's not, so this is sort of an interesting thing. I mean, if you say in the abstract, the president perjured himself in front of the grand jury, that sounded to a lot of people as if that is a very serious thing. That is a high crime or misdemeanor. You're charged with the faithful execution of the laws. You shouldn't be lying, intentionally lying to a grand jury. The defense was that, in a sense, what he was lying about was a sexual relationship that, however inappropriate, was consensual, and that he, and this was not a high matter of state. And judging by the public reaction, it'd be interesting to know whether the public would react quite the same way, even to the idea of its being consensual in 2019. But at the time, the whole proceeding just drove his approval ratings up. I mean, by the time he was acquitted, his approval ratings, I think, were in the 80s. So that tells you what the public thought of that. We now have a very much fractured media environment, so that a couple of things that happened during Nixon or Clinton were not happening now, which is you don't have network primetime coverage of every day's congressional proceedings. And there are many more outlets from which to get your news. So, there are, of course, the networks, but there's cable news, there's your social media threads. And I think it's fair to say that public opinion, I mean, the majority, if you believe current public opinion polls, the majority thinks that these accusations are serious. The public seems to be pretty evenly divided about whether they're serious enough to warrant removal from office. My own judgment, and I don't get a vote, is that the allegation, if substantiated, that the president was leveraging national security assistance to an ally to get them, without a valid national security reason, to investigate or to announce an investigation into a political opponent. It's not even clear that he needed the investigation. He wanted the investigation announced. That does seem to me to be a serious abuse of office. I would also say that obstruction of justice seems to me to be a serious abuse of office. And so, again, to the extent you think that anything in the sort of Mueller 10 incidents from the Mueller report amounts to obstruction of justice, I think those would be impeachable offenses. A closer question is the emoluments clause. So, as you may know, there's a big debate about whether President Trump is in violation of the emoluments clauses. There are two of these in the Constitution. One is a flat-out bar on the president receiving any emolument from the federal government other than his salary or from the states. And then there's a conditional bar against foreign emoluments, which says the president shall not receive any foreign emoluments without the consent of Congress. And on this basis, for example, Jimmy Carter divested his peanut farm. President Kennedy was not allowed to accept an honorary citizenship from the Republic of Ireland. But those people didn't own hotels. So the question is posed whether President Trump is in violation of the emoluments clause because he still retains a financial interest in private properties that are being patronized both by the states, which might be in violation of that clause, and by foreign governments. I want to say I think that's very serious, but there is so little precedent about how to handle this when a president resists. It's not, it's not money that's going. There's enough kind of a legal cloud around what exactly the law is here that I think the president's lawyers would have a non-trivial argument that there's not enough of a consensus as to what this amounts to for it yet to be impeachable. On the other hand, the House could say, well, you know how we're going to create a precedent? We're going to declare that your failure to do this was a violation of the emoluments clause, and that'll make it a precedent. But we'll see. But I'm not at all confident that that's going to be treated as an article of impeachment. A long answer to your question. Yes?
I've heard different talks about the role of the Supreme Court in this process. Can you describe what they might contribute in the process, and at what point would they intervene?
Right. So the short answer, and again, crystal ball, weak battery, confident answer, they will do nothing. Now, the reason I say this, and again, I'm undoubtedly going over territory that's familiar to at least some of you. The Supreme Court has identified a category of constitutional questions that they call political questions. And by political, they don't mean partisan or having to do with politics. They mean that as they see the Constitution, as they understand the Constitution, the resolution of some dispute was intended to be resolved by the elected branches, not by the court. So an example of this, although this was a plurality decision, the Supreme Court declined to come up with a rule as to who gets to back out of a treaty. Does the president need congressional authority, or can he just do it unilaterally? In an opinion by Justice Rehnquist going back to the Carter administration, he said, this is not for us to decide. Congress and the executive branch can work this out. There is a case called Nixon versus United States, not to be confused with United States versus Nixon. United States versus Nixon involved Richard Nixon. Nixon versus United States involved a judge federal judge in Mississippi named Walter Nixon. And Walter Nixon was tried and convicted of bribery, but he had not yet been impeached and removed. And it was his position that, unless he resigned, which he didn't feel inclined to do, that, federal prison receives mail, he'd be happy to receive his check as a federal judge and continue to be on the federal payroll even while in prison. And the House and Senate didn't warm to that. So he was impeached by the House, and the Senate held a trial. The way the Senate conducted the trial, they had all of the evidence heard by a special committee that was designated for it. And then the committee made a report to the Senate floor about what they had found. The Senate also heard closing arguments from counsel representing the House of Representatives, the floor managers for the impeachment, and from Judge Nixon's lawyers. But they didn't actually, there was no witness testimony in front of the full Senate. That was done entirely to a committee. So Judge Nixon went to federal court and said, I didn't get a trial. I was denied the trial I was entitled to because the Senate didn't try me. They delegated the taking of evidence to a committee. And in an utterly remarkable opinion, not the outcome, but just the way it was written, the court said unanimously, there may have been a dissenter, that this was a political question, that the Senate had the sole power to try impeachments, and what amounted to an adequate trial was entirely for the Senate to decide. Now, the reason I say that the opinion was remarkable is that the Supreme Court said, by using the verb to try, and the Senate has the power to try impeachments, the framers had chosen so vague a verb that they could give it no certain legally enforceable content. Which means that a majority of the Supreme Court, the highest jurists of the United States, who recognized pornography when they see it, wouldn't recognize a trial when they see it. A friend of mine once said the Supreme Court says some things sometimes that they can't possibly mean. And I think, they're sending a message there. And the message is, impeachment is not this is not our job. Now, there was a particular, I think, institutional reason for staying out of that impeachment, which is that the court implicitly recognized that impeachment is the only way to get rid of misbehaving judges. Judges hold their positions, as the Constitution says, during good behavior, which is basically for life, unless they decide to resign. So unless Congress has this authority to remove them, there's no dealing with the judge who wants to receive his salary while still in prison. So the court, I think, implicitly recognized they would have a huge conflict of interest, saying to Congress, yeah, you get to get rid of us, but we get the final word. That would have been institutionally very problematic. In the case of a presidential impeachment, there is arguably a worse problem, which is the Constitution sets up one person to be president, and that one person to be president idea is nowhere more important than with regard to military command. Right? The president is made the commander-in-chief of the Army and the Navy. It's been accepted that that carries over into the Air Force, although again the Constitution doesn't actually say that. But there's one commander-in-chief. Why? Because the last thing we want is multiple voices sending orders or instructions about what is military policy, particularly when we have men and women in harm's way. The Supreme Court, I am confident, will never undertake a role that will create a moment's doubt as to who is president of the United States. They will not get in front of the question while it's still in front of the Senate, and if the Senate convicts the president, they will by return mail, they'll say, we're not doing anything about this. Now, another question that, where they could indirectly get involved, might be on questions of executive privilege that are arising with regard to the testimony of particular witnesses. That's interesting. I don't know what the court's going to do. They have before them now questions about both the New York Attorney General's subpoena and a congressional subpoena for the president's tax returns. It's unclear what they're going to do about that. It's on administrative hold right now, but they haven't announced whether they're going to take those cases. Those are weighty cases. I will say administrations prior to the Trump administration pretty consistently took the position that executive privilege does not apply when it comes to subpoena testimony during an impeachment proceeding. That's obviously not the current administration's position, but whether the court would get involved, I don't know. But clearly they're not going to get involved in what is an impeachable offense or whether the procedures were adequate if the president is removed. That I'm sure of. Yes?
So I have a question about the, so you mentioned earlier that the Constitution says impeachment can only go so far to remove and then bar from holding federal office again.
Right.
So in watching the debate last night, I think there's been a lot of questions of, even if it gets to the Senate, will he actually be impeached?
Will he be removed?
Will he be removed, right? Then can he be criminally charged by a potential next president in 2020? So how does that line in the Constitution play in that? And I guess kind of related to that, then, so Ford then pardoned Nixon after he resigned
Right.
from office. So like what were kind of the details surrounding that? Why he needed to be pardoned if that clause is in the Constitution?
Well, okay, so there's a lot there. That's a very interesting set of questions, obviously. So if the president is not removed, of course, he continues to be president through the end of his term or into a second term if he's reelected. There is a significant debate about whether sitting presidents may be indicted. The Office of Legal Counsel, which is the Justice Department office for which I worked during the John Quincy Adams administration, has opined on a couple of occasions that sitting presidents may not be indicted and tried. I think it's fair to say there's not a legal consensus about that outside the Justice Department, even though the fact that they took that position was binding on independent special counsel Robert Mueller. Interestingly, one of the dissenters, so there is a friend of mine who unfortunately died about a decade ago, named Ron Rotunda. He was a very well-known conservative constitutional law professor at the University of Illinois for many years, and then I think he finished his career at George Mason. He was hired to look into this question for the Clinton impeachment, except for the independent counsel investigation that started with Whitewater. So basically, Ken Starr hired him to do an independent constitutional analysis about whether sitting presidents could be indicted and tried, and his view was that they could be. He wrote a very long memo to that effect. And one of the Republican lawyers who's actually been kind of most outspoken against the president's current position is a guy named Paul Rosenzweig, who was a deputy of Ken Starr during the Clinton investigation. So there's still a lot of dispute about that. In practical terms, nobody's holding their breath waiting for this Justice Department to, indict a sitting president. As a former president, there's no bar to his being indicted and tried, depending on the sufficiency of evidence. And I think there is consensus about that. The only thing, there might be a question about the statute of limitations, if there's an applicable statute of limitations. It has been argued that since the Justice Department takes the position that the sitting president can't be tried, that the statute of limitations should not be deemed to start until the person's out of office. So that would be another legal fight to hold. But just in terms of the susceptibility of a former president to criminal charges, I don't think there's any question about that. As to the pardon, President Ford made a judgment that that what used to count as polarization was, now it seems those were friendly times. I mean, we didn't know it was coming, but it seemed awfully polarized back then in the early 70s. That the way to get past it was to pardon the president. Again, whether he was right or wrong, we don't know. That certainly is within a sitting president's authority. I will say, and I've written this, so I'm just repeating something I've said. I don't like it when presidential candidates say, "Elect me president, and I will lock him up," because, and I say this as a former Justice Department lawyer. Yes, the Justice Department and the White House have a relationship, an institutional relationship, but when it comes to the charging of particular offenses and defendants, it should really be an arm's length relationship. And so, whether, even if the next president is a Democratic candidate, not a Republican candidate, I would hope that that person would say to whoever is his or her attorney general, whatever you do is fine. I'm not going to push you. I'm not going to pull you. I'm not going to say anything about this. It's in your court. Yes.
So speaking of polarization, I would agree by 2/3 vote to impeach the president, or let alone 2/3 vote on anything?
You've deprived me of my own snarky answer. I mean, trying to get cloture on the question whether the sun rises in the east has become hard, and that's only 60 votes, right? So, I think there's next to no chance. But, former Arizona Senator Flake has said, if there were a secret ballot, there would be 30 to 35 votes among the Republicans to remove the president. I think people watch the polls pretty closely. I don't know if what's being said this week will or will not, move the needle sufficiently, as they say. So, I'm a notoriously bad gambler, but I'm not putting any money on removal. And I think, the House understands that. I think, my understanding is that the managers of the Clinton impeachment in the House, including Lindsey Graham, were surprised and disappointed that they didn't pick up more votes in the Senate. And I don't think the House managers of this impeachment are going to walk in thinking, we've got this nailed. Yes, sir.
So he's not convicted. Do you think that helped the trial? Do you think that helps him to get reelected or not? Like Johnson didn't get reelected after the trial.
Well, I don't. So, again, this is outside my.
Your opinion.
Right. This is outside my expertise. I think what Trump at one point, if I understand his Twitter feed correctly, I want nothing. Oh, I'm sorry. That was yesterday. So if I understand his position correctly, at one point he was saying, he kept saying, I want the House to impeach me. Go ahead and impeach me. I dare you to impeach me. And what that was all about, seemed to be his thought that if they impeached him, it would have the same impact on his numbers that impeaching Clinton did for Clinton. But there are at least two differences. One is that there's a very different public assessment about the seriousness of the charges about President Trump. Again, not everybody obviously thinks that they're serious enough to count as high crimes and misdemeanors, but nobody thinks that they are trivial as compared to, I shouldn't say nobody. The majority of Americans do not regard them as being in the same ballpark as what President Clinton was accused of. But the second thing is that on the key issues of domestic policy, that the public was paying attention to in 1998, Clinton was decisively on the side of the majority opinion on all of those issues. I mean, every time, he kept saying over and over again, education, environment, education, environment, and and the public was with him on that. The public, I think, is not behind the current president in terms of domestic policy, in part because it's not so clear what his domestic policies are. But I don't just mean that, I can't remember. I honestly can't remember this week. Are we backing off the tariffs? Are we reinforcing the tariffs? We're doing one of those things. And I think the public is not going to rally around that in the way it did around the president. So it may be, I don't think the impeachment is going to help him, certainly not going to help him the way it helped Clinton. Whether it will hurt him, I don't know. There obviously, there seem to be 35 to 40% of the people polled who are with him no matter what. I don't think that that's going to go down. So, will this hurt him in the suburbs we're now all talking about? Again, crystal ball, weak batteries. Yes, all the way in the back.
I've heard it said that, thanks so much for what you've shared.
Sure.
Great. I've heard it said that impeachment is like, it's a political process and that, like you were saying, the public opinion is kind of what drives some of these votes and things. To what extent do you think that including some of the other things that have happened in the last 4 years in the articles of impeachment will affect the outcome with the public and with votes? What I mean by that is like,
Yeah.
Do you think they should include or will include, let's not even say should, let's keep it just a second. Do you think they'll include obstruction of justice from the Mueller report and emoluments and this stuff with Ukraine? Because it seems like the formal impeachment inquiry
Right.
is just focused on the Ukrainian stuff.
Yeah, so again, my prediction, if any of you are wagering money based on this, you are, you're going to sue me for malpractice. I think there will be an article based on Ukraine. I think there will be an article based on the forms of obstruction of justice referred to in the Mueller report. I think there will be an article of impeachment dealing with failure to cooperate with the House impeachment investigation. And I think there may be an article about witness intimidation. I don't think there will be an article based upon emoluments just because of the legal uncertainties surrounding it. And there are other things. This president seems in important ways, to be evading the Senate's advice and consent power by putting, acting people constantly in place. I mean, he has statutory authority to do it, but he's arguably abusing it. But again, I think that's kind of too administrative law-ish for an article of impeachment. So I think if I had to predict, my prediction would be those for Ukraine, Mueller obstruction, Congress obstruction, and maybe witness intimidation. Sure. Yes?
In terms of the phrase high crimes and misdemeanors, what are the legal and political arguments for either clarifying that or keeping it intentionally vague?
Well, I think, so again, I want to say, the point was made that the process is often described as a political process. I would like to think of it as being sort of small p political, that it reflects the interaction of, a calculation as to the appropriate interaction of political institutions. And so a judgment has to be made, what's good for the republic, if I can put it that way, not just what is or is not in technical violation of the criminal code. So I think specifying, well, let me put it this way. If someone, imagine we can go back in time, even just to 1973, 1974, and somebody said, we ought to have a code that indicates specifically what we mean by high crimes and misdemeanors. Would anyone have had the imagination to think that that code should include the leveraging of our foreign military assistance to extort an investigation of the president's political opponent? I doubt it. And again, if Congress reaches the judgment that that's what's happened, there's no doubt in my mind that that's a high crime or misdemeanor. So I think the argument against certainty is our collective crystal ball comes with weak batteries. And the reason, and so go back historically a bit. The first draft of the clause had treason, bribery, and I think it was, I'm trying to remember which of the framers, but somebody, it may have been Governor Morris, had used the phrase maladministration. And Madison said, we don't want maladministration because that could be anything. That could be wasting paper clips once they're invented. So maladministration is just too general. We don't want the president to be just the supplicant of Congress. It is a co-equal branch. So in deliberation, they said, okay, fine. But we don't want to just leave it at treason and bribery. We want a broader category of grave offenses against the public. Hamilton, again in the Federalist Papers, famously said that these are offenses political in nature, in that they are offenses against the state. But we don't want to specify what they are, and that's exactly why they chose high crimes and misdemeanors. So they made a choice in favor of vagueness, and I think history has probably proved that what they did was the better alternative. It's interesting. The way we behave constitutionally has as much to do with history as with text. I mean, for all, Congress, the first Congress could have decided, every time the president vetoes some legislation, we're going to impeach and remove him. Now that sounds itself unconstitutional, but it's not clear what would have stopped it. Or they could have, the first federal impeachment, which resulted in an acquittal, was a Supreme Court justice named Samuel Chase. He was impeached basically because of his political views, which he expressed intemperately while a justice, particularly sitting riding circuit in Maryland, and the Senate refused to convict. That set a historical precedent that, at least for judges, unpopularity of stance could not be impeachable. I think that's a good thing. But again, they could have taken the opposite view, and there's nothing in the text of the Constitution that would have said no. I mean, so that's the cost of vagueness. The cost of vagueness is you're depending on people being responsible when it comes to interpreting it. But I think the future being uncertain, vagueness is better than the opposite. Yes, sir.
Earlier
Yes,
we
yeah.
talked about kind of that scheduling, so it moves from the House to the Senate. What kind of time lag is there? Are we talking months? How much control does, say, Mitch McConnell have about, we're going to wait till after the primaries, we're going to wait till a month before the,
Right.
Is there any precedent or anything in their procedures that say, hey, you've got to do it within a week of the articles arriving, or is that, again, discretion?
Yeah, so I honestly don't know the technical answer whether the Senate rules specify a time limit, but even if it specified a time when it has to start, the majority leader would still have enormous control over the pacing of things, how many days a week, how many weeks, and so forth. I mean, the Constitution itself requires Congress to convene every January 3rd, and the way they convene is generally, some senator from Virginia or Maryland comes in, wraps the gavel in an empty chamber and says, see you in a few weeks, which itself might be unconstitutional, but that's the Senate makes its own rules. So again, there's a lot of speculation. At one point, it was reported that Majority Leader McConnell expected impeachment articles to be reported by Thanksgiving, in which case the trial could be over by Christmas. I don't know if the first part was ever going to happen. He pretty much guaranteed it would not happen by allowing that to be reported. And now the question is, short trial or long trial? And again, the Twitterverse is alive with the idea that the majority leader wants to prolong the trial because that will make it very hard for Senator Sanders and Senator Warren and Senator Klobuchar and Senator Harris to deal with the Iowa primary because they'll have to be in Washington. Well, again, this is just pure speculation. I'm the Senate majority leader. I want a Republican elected in 2020. Does prolonging a trial of the incumbent president, who will almost certainly be our candidate if he's not removed from office, prolonging his trial to make it harder for some of the leading Democratic senators to get votes in Iowa? Is that a sensible political move? I mean, my guess is that the senators would take the view, we'll give you Iowa, make this 7 days a week, and run it through the end of February. That sounds great to us. I don't see how that is a good Republican campaign strategy. But nobody calls me for political advice, and certainly not the Senate Majority Leader. Yes.
I think it was earlier this week that Speaker Pelosi had presented President Trump with the opportunity to testify on his own behalf. So in either, I think, written form or sitting in for himself, like an in-person hearing. I just didn't know, what is the precedence with a president doing that? And if you were providing legal counsel to President Trump, would you advise him to do so?
Well, I would not advise the president to offer in-person testimony. I think there's a technical, it would be insane to do that. So no, that would not be my advice. It was sort of an interesting move, and I think the speaker was picking up on, an interchange that had happened during the Intelligence Committee hearing, where one of the president's defenders said, we're not getting to hear from the people, who are really, know what's going on, and then one of the Democratic members said, well, if the person who set everything in motion wants to testify, let's hear him. It's not a risk-free thing to say out loud for the speaker, we would welcome this, because that puts a question of timing now in the White House's hands. He could say, oh, yes, I want to offer written testimony, but I'll need 6 weeks or 8 weeks to do my answers. So, that itself could be a little bit of a battle. What the president said, again, on Twitter, is that he would strongly consider this. Again, if you'll pardon my snarkiness, I'm not sure if anybody's compiled a list of things he has strongly considered and then actually done. But I don't think it represents a commitment to do it. And I think unless a very concrete offer is made quite soon, I don't see it happening. But clearly the risks would be too great. Now, one thing that has come up, and it's interesting, nobody asked me about this. So a very well-known, actually, law professor named Steve Calabresi at Northwestern, he's a co-founder of the Federalist Society, and a serious person, wrote a blog post indicating that the House proceedings were in violation of the Sixth Amendment, which is remarkable, because the Sixth Amendment, as clearly as the Constitution says anything, it says the Sixth Amendment does not apply to impeachment. It starts out for all criminal prosecutions, and again, impeachment isn't. And if you had doubt about that, one of the rights that you would have, if it applied to impeachment, would be a right to a jury of your peers in the state or district where the crime occurred, which would mean that no president could ever be impeached for anything that happened outside Washington, D.C., which seems odd. And also, the Senate's a jury. I mean, it just doesn't make sense. So the procedures in the House, which with a little tweaking are not unlike the procedures that were afforded during the Clinton and Nixon impeachments, sort of parallel the House's role as a kind of grand jury. And in a grand jury proceeding, the target's lawyer is not sitting with the grand jury. They don't question the witnesses in front of the grand jury. They have to wait for the indictment and the trial. And whether the president would choose to appear, so the rights that we think of as being more due process-y really come into play at the Senate trial. The Sixth Amendment still doesn't apply, but the Senate does have procedures that for the taking of testimony. I still, if I were the president's lawyer, I would strongly urge him not to testify in front of the Senate. But ratings. So what can I say? I think if he insisted, the procedures would allow for it. Yes.
Has Giuliani committed any crimes that you think he'll be indicted for?
I am is the subject now of multiple criminal investigations. I'll say that. We have time for one more, or? Yes.
So I've just been thinking about what you said in terms of social media and the role that Twitter has played in all of this, and President live tweeting as hearings are going on. What role do you think now this information with social media and him playing such a big role in that has on public perception of the legitimacy of democracy and these kinds of proceedings? Does his banter on Twitter kind of degrade democracy and these checks and balances that are put in place for a reason?
Well, that's a very big and important question, and I guess I would just say this. I think to the extent any president facilitates a kind of cult of personality, that degrades democracy. And I will say, and I sort of understand this, but there's been a trend, in a way, the current president's norm-breaking behavior in that respect is just ramping up a kind of trend that I would say has been clearly in the works since the Clinton administration, and it's been bipartisan, which is presidents have started speaking of everything the executive branch of government does as them doing it. This is very misleading. But when President Clinton said, I'm going to regulate tobacco, when President Bush said, I'm not going to regulate stem cell research unless it's existing lines, when President Obama says, if Congress does nothing on gun control, I'm going to take action. And you can hear this also. I mean, I think it was Senator Harris said she's going to, prosecute President Trump. I think Senator Warren has said she's going to stop all fracking everywhere on day one. No, you're not, right? And I think, and if I had a wish, it was, and maybe, again, this is naive or just, this train has left the station. But even in our era of I would say, a pathological concern with celebrity. If we could get back to the president being the head of government and not the celebrity in chief, that would be a very healthy thing. And thank you for allowing me to close on that editorial.